Morning, people are just coming through, so we'll just wait for a minute or two before we kick off this morning. I think people are coming through, so I'll just hang on for a second before kicking off. Great, well, good morning, everybody, and a very warm welcome to BDB Pitman's first employment webinar of 2023. I'm Nick Riche, one of the partners in the employment team, and today we'll be trying to anticipate what we can expect in the world of HR and employment law for the next 12 months. What will be the key legal challenges, important cases, consultations, and trends that we should be looking out for this year. Tea leaves and crystal balls at the ready are Asten and Chris Greep, who will guide us through all the latest developments. Now, after Brexit and COVID has dominated Parliament's time in recent years, this year looks like one of the busiest years we've had in a while in terms of either new employment laws or consultations with a chance of future changes, whether that's changes to how you handle flexible working requests, greater protection for those returning from maternity, adoption, or shared parental leave, or a new duty to prevent sexual harassment. There's a lot to keep track of this year. Now, what's slightly confusing is that a lot of these changes aren't in just one employment act, but several different private members' bills brought by individual MPs rather than the government. This means that the changes could all be brought in at different times, but we'll do our best to let you know how far they've got. And Asten will talk about this more a bit later. And she'll also have a look at some of the most important cases that we'll be seeing for 2023. Before we get to that, what's going to happen this year, Chris will recap the key cases that have already been decided and what impact they could have in the future. We also can't escape an employment law update without mentioning Brexit, and the EU law bill has the potential to scrap a number of employment laws which have their origins in European legislation. Chris has the pleasure, or possibly has drawn the short straw of talking about this complicated topic and whether the bill really will go as far as it's been threatened to. Now, before Chris starts us off, I'd like to cover just a few housekeeping points. We've got all the normal Zoom buttons at the bottom of your screens, and I'd just like to highlight the Q&A button in particular. This is where you can ask questions about what we'll be talking about today, and we'll get a chance to discuss these at the end of Chris and Asten's slots. If there are questions which we haven't had a chance to answer today, then we'll be sending out our responses together with today's slides in the next few days. But I'm hoping we'll get through a decent number of questions, and so please do ask anything that comes to mind, as we'd love to hear from you. Just make sure you use the Q&A button and not the chat function. The chat function can be used if you're having any technical problems, and Megan in our team will help you with those. I think those are all the main kind of housekeeping points and introduction from me for now. Thanks again for joining us, and I'll now hand over to Chris to kick things off.
Thank you very much, Nick, and good morning, everyone, and welcome to our first webinar of the year, as Nick said. So the first topic that I'm going to be covering this morning is some important cases from 2022, which are likely to have an impact on 2023. So if we go to the next slide, please. The first case that I'm going to be covering this morning is Rogers and Leeds Laser Cutting Limited. So this is one of the first appeal cases dealing with COVID-19 and safety in the workplace. So it's a Court of Appeal decision which relates to the application of section 101D of the Employment Rights Act 1996. And section 101 sets out when an employee will be regarded as having been unfairly dismissed for health and safety reasons. A dismissal under this section will be an automatic unfair dismissal, and so there's no requirement for the 2-year service requirement. So an unfair dismissal will be an unfair dismissal for the purposes of this section 101D if the reason or principal reason for dismissal is for the employee leaving, proposing to leave, or refusing to return to a dangerous workplace or any dangerous part of their workplace where an employee reasonably believed that they were in serious and imminent danger and they could not be reasonably be expected to avert it. So the facts of this case are going all the way back to March 2021, the day after the first lockdown was introduced. The employees of Leeds Laser Cutting Limited were told of measures that were being put in place to protect staff from COVID-19 as they're working in a laser cutting environment, which is not something they were able to easily go and do from home. So they were required to continue working during the lockdown. So Leeds Laser Cutting employed an external health and safety advisor to undertake a risk assessment, and discussions were held with staff to consider suitable measures to introduce. So introduced social distancing, hand washing was a requirement, and masks were available to all staff who requested one, and Mr. Rogers was a staff member who did not ask for a mask when they were offered to him. Social distancing was available for the most part, but there were some instances where this was not possible, but these were brief, and Mr. Rogers did not raise any concern on the occasions where social distancing was not possible. So a few days after this, on the 29th of March 2020, Mr. Rogers texted his line manager to say that he'd be staying away from the workplace until the lockdown had eased due to worries about infecting his vulnerable children. And he was then in a period of self-isolation from the 28th of March to the 3rd of April 2020, and no further contact was received from Mr. Rogers after that date. On the 28th of April 2020, he was dismissed for being absent without leave or explanation. Following this, Mr. Rogers brought an employment tribunal claim alleging that his dismissal had been automatically unfair because he had exercised his rights under section 101D of the Employment Rights Act, this being that he had left a dangerous workplace because he felt he was in serious and imminent danger. Mr. Rogers said in his evidence that he wasn't sure of any additional safety measures that would have made him feel safe enough to return to work. However, despite the concerns he had driven a friend to the hospital during his period of self-isolation, and he had worked in a pub during the later parts of the pandemic. In the first instance, the Employment Tribunal sided with Leeds Laser Cutting Limited, finding that Mr. Rogers had not established a reasonable belief in a serious and imminent workplace danger. He had taken no steps to try and avert any danger, nor had he raised any concerns with his manager before absenting himself from work. An appeal was raised to the Employment Appeal Tribunal, who sided with the Employment Tribunal, finding that there had been no error of law and they had been entitled to find that the claim was not made out on the facts presented to it. Mr. Rogers appealed it once again, and the Court of Appeal was hearing the claim and dismissed the appeal of Mr. Rogers for essentially the same facts as the Employment Appeal Tribunal and the Employment Tribunal. And what the court did do was provide some helpful guidance on the approach that needs to be taken in cases that are brought under these circumstances where an employee is alleging that they are in serious and imminent danger in the workplace. So the approach that needs to be taken is answering a series of questions, these being, did the employee believe that there are circumstances of serious and imminent danger at the workplace? If so, was that belief reasonable? If so, could the employee reasonably have averted that danger? If not, did they leave or propose to leave or refuse to return to the workplace or the relevant part of the workplace because of that perceived serious and imminent danger? And if so, was that refusal to return or the decision to leave the principal reason or the reason for dismissal? The Court of Appeal provided clear authority in this case that the danger must arise at the workplace and the employee must believe they're subject to that danger as a result of the workplace, meaning that whilst there can be danger at large, like the pandemic, there's danger in lots of different situations, the employee must reasonably believe that that danger has to be present within the workplace and that that danger presents a serious and imminent threat to them inside of the workplace or a part of the workplace. In Mr. Rogers' case, he couldn't show that because the measures that had been implemented by the employer to reduce the risk of transmission meant that there would not have been a reasonable belief in a serious and imminent danger inside of the workplace. I think Mr. Rogers' case revolved more around the concerns of COVID generally, and so he didn't have a real and suspected thought of danger within the actual workplace as being afraid of catching COVID-19 because of a lack of measures being introduced by the employer. So it's important to see how this case works, as it will be important to show that the employee's reasonable belief that the serious and imminent circumstance that they're afraid of is in relation to the actual workplace. And I think this section was probably drafted not with a pandemic or a virus in mind, with the case in mind likely to be one where there's serious and imminent danger in the workplace because of the premises or because of equipment or systems that aren't working that may result in an accident. And if we go to the next slide, please. So the next case is one which most of you are probably aware of. It's been a long-running battle between Mr. Smith and Pimlico Plumbers. Mr. Smith has already been through every court possible up to the Supreme Court to determine whether he was a worker or not, with the Supreme Court eventually determining that he was. And so the case was remitted all the way back to the Employment Tribunal to determine his holiday pay claim. And that has gone all the way back up to the Court of Appeal, which has determined his holiday pay claim. So a bit of background, just in case there are some of you who aren't aware of this. So Mr. Smith was a plumbing and heating engineer. He worked for Pimlico Plumbers from August 2005 to May 2011. And throughout that period, Pimlico maintained that Mr. Smith was a self-employed contractor. He had no entitlement to paid annual leave. And following a dispute between the parties, the relationship came to an end in May 2011, with an employment tribunal claim being presented in August 2011. So the issue for the Court of Appeal to decide in this case was the issue of the denied holiday that Mr. Smith had said that he was entitled to. So throughout the outset of the relationship, Pimlico maintained Mr. Smith's status as a self-employed contractor and therefore was not entitled to annual leave or paid leave. The Court of Appeal determined that the claim was for a denial of the single right to take paid annual leave because the employer disputed that right and refused to remunerate the annual leave. The approach taken by Pimlico had prevented Mr. Smith from exercising his right to paid annual leave throughout the duration of his contract. And the court found that since he could only lose the leave if he had the opportunity to take it, then the right to annual leave accumulated year on year and crystallized on termination of his contract. This followed the approach of the European courts in the case of Shimzu, which held that a national law cannot provide for the automatic loss of accrued but untaken annual leave where the employer, unless the employer could show that they have provided an effective opportunity to allow the worker to take that annual leave to which they're entitled. The burden is on the employer to show that they have provided opportunity to do that. And in this case, Pimlico had not shown that they were doing that, as they had prevented Mr. Smith from taking paid annual leave because they said that he was not entitled to that leave. And so the court found that that leave accrued year to year and a payment was due on termination. So the key takeaway from this claim is that where a worker has been denied the right to paid leave throughout the time that they are considered to be a worker, then the right to paid annual leave under the Working Time Directive will accumulate year on year, and a payment will be due on termination, as this is when the payment will crystallise, as there's not been a deduction from wages or an unpaid holiday because no leave has been taken. This means that there's no series of deductions, and so the 3-gap rule established in Bear Scotland won't assist employers here. This rule being that where there's a gap of more than 3 months between deductions, then this breaks the series of deductions. And so as this claim is for a single payment due on termination, Bear Scotland doesn't help us here. It is important to note as well that the leave that would carry over for employees for workers or employees in this situation would be the 4 weeks leave granted under the Working Time Directive, and not for the additional 1.6 weeks under Regulation 13A of the Working Time Regulations. So it's only 4 weeks, not the full 5.6 weeks that continue to carry over. One interesting point that did come from this judgment, it wasn't expressly stated in the judgment as a decision as part of this case, but the Court of Appeal did express a strong provisional view that the ruling in Bear Scotland regarding the 3-month deduction is not correct. And so this is something that we're likely to see challenge in the near future, and I believe Asten will be covering a case that could challenge this in 2023. So if we go to the next slide, please. So the next case is a case of Forstater and CGD Europe. So this is a really interesting case regarding the Equality Act 2010 and what can constitute a philosophical belief for the purposes of the Act, and so having a philosophical belief protected for discrimination purposes. So Ms. Forstater held gender critical beliefs. So these beliefs were that a person's sex is determined genetically, and that's determined at birth, and that this should not be conflated with gender or gender identity, believing that a person can identify as another sex and they can legally change their sex under the Gender Recognition Act, but that doesn't actually change their sex, as that she believes this is allocated at birth, and that's the end of it. So Ms. Forstater engaged in numerous debates on social media about gender identity. A lot of her views were found to be very offensive by those in the trans community and also her colleagues. Her beliefs were stated on her social media to be her own. She said that they're not the view of her employer, but she did bring her views into the office, sometimes engaging in conversations about her beliefs, and some of the remarks she made were found to be offensive by some in the workplace. Some of her colleagues complained about the remarks that were being made, and following an investigation, her contract was ultimately not renewed, and so her engagement with CGD Europe ended. Ms. Forstater claimed that the decision not to renew her contract amounted to direct discrimination due to her gender critical beliefs, which she argued amounted to a philosophical belief under the Equality Act 2010. She also brought claims for indirect discrimination, harassment, and victimisation, all with the protected characteristic of her philosophical belief. An employment tribunal had to consider at a preliminary hearing whether Ms. Forstater's gender critical beliefs could be considered a philosophical belief for the purposes of the Equality Act. In order to do this, they would need to run through the Grange criteria, which set out a test for a belief to amount to a philosophical belief, these being that the belief must be genuinely held, must be a belief, not an opinion or viewpoint. It must be a belief that has a weighty and substantial aspect of common human life and behaviour, and it must contain a certain level of cogency, seriousness, cohesion, and importance. The final criteria is that the belief must be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with the fundamental rights of others. The Employment Tribunal found that the beliefs of Ms. Forstater met the first 4 criteria, but failed under the criteria of having being worthy of respect in a democratic society. So the Employment Tribunal found that there was no philosophical belief here and therefore no discrimination. Ms. Forstater appealed, and the Employment Appeal Tribunal actually overturned the Employment Tribunal's decision and found that the beliefs of Ms. Forstater were eligible for protection under the Equality Act 2010, and set out a little bit more on what types of beliefs can be worthy of respect in a democratic society and not incompatible with human dignity and not conflict with the fundamental rights of others. The Employment Appeal Tribunal looked at European case law on this point, and they found that only the gravest form of hate speech, which incites violence or hatred aimed at destroying the rights and freedoms of others, are excluded, and found that whilst beliefs can be shocking, offensive, or disturbing, then they can still be protected under the legislation. The claim was then remitted to an Employment Tribunal to determine the Equality Act claims, so the discrimination claims, with the direct discrimination being upheld in relation to the decision not to offer a new contract because of the gender critical beliefs that Ms. Forstater held. So it's a decision on a much debated topic in society at the moment, and it's certainly going to have an impact on the scope of legitimate expression of beliefs in the workplace. The Employment Tribunal also acknowledged, when determining the direct discrimination claim, that where a belief is protected in the workplace, then straightforward statements about that belief will also be protected. And this is quite an interesting point, as it's going to show really how fact sensitive all of these cases regarding this topic are going to be. Some of the statements that Ms. Forstater was making were statements that are certainly going to be offensive and shocking to a large number of people, statements such as trans women are men, and this is going to be disturbing to a large number of people, but this was found to be a straightforward statement about a belief. When you sort of put this up against situations where someone is deliberately misgendering someone in the workplace, who has asked for certain pronouns to be used, and someone is deliberately disrespecting that and using alternative pronouns which they find to be offensive, this issue is unlikely to be protected in that sort of circumstance. So it's really important to just take each situation on its facts. And I think all future cases on this topic will no doubt be the same and show that the facts of each case will be very different. But usually where we're having targeted statements and individual, these are much more likely not to be protected because of the lack of, because they effectively could be attacking convention rights under the European Convention on Human Rights. It's difficult to implement hard and fast rules on this because of the fact sensitive nature of the cases. But one of the main takeaways is the fact that it's important to be aware that beliefs that may not be popular in the workplace or may not be popular in society, and which could be offensive to a wider workforce, may actually be protected under the Equality Act. So it's just being aware of those sorts of circumstances. And the next case on the next slide, please. So this is Mogain and Bradford Teaching Hospitals NHS Foundation Trust. And this case is a redundancy consultation case, which was heard by the Employment Tribunal and then later the Employment Tribunal. So the claimant in this case was employed on a series of fixed term contracts. She was invited to attend a meeting and told of financial problems that were faced by the respondent, and a consultation process was then to be agreed and implemented. Before that process was due to take place, a decision was taken on the selection criteria for the redundancy consultation, but the only criteria that was selected was that the claimant's fixed term contract was going to be ending sooner than her colleague. And so she was effectively placed in a pool of one with a single selection criteria. Following this decision being made, a consultation process was started, but the process focused on alternative employment and trying to offer something to the claimant, which was eventually offered, but it was not deemed to be suitable alternative employment. In the first instance, Employment Tribunal found that the dismissal was fair, but this was appealed, and the Employment Appeal Tribunal overturned this and substituted this for a finding of unfair dismissal. The Employment Tribunal found that the Employment Appeal Tribunal found that the Employment Tribunal had overlooked large aspects of the issue of consultation when they were deliberating the reasoning for their judgment. The EAT found that they had conflated consultation on alternative employment with the broader duty to consult in a redundancy situation, finding that the consultation is a fundamental aspect of the procedure being deemed to be fair. So in order for a consultation to be fair, it must be genuine and meaningful, and it must take place at a formative stage when an employee can still have an impact on the potential selection for redundancy. In this case, the choice of selection criteria effectively made the choice for redundancy before the consultation had even started. And so it was found that this was a failure under the requirements to have a fair procedure under the Employment Rights Act. So this is just an important reminder really of consultation obligations, especially in circumstances where there is a pool of one. It's important to ensure that decisions are taken, the decisions aren't taken prior to consultation, and that all consultation is genuine and meaningful and taken at a time when the consultation can still have an impact on the decision to make an individual redundant. So if we can move on to our final case, and it's one that I'm sure most people will have heard of, and it's not an employment tribunal, not an employment webinar if we don't talk about Brexit, holiday pay, and now Harper Trust. So Harper Trust and Brazil is a case that went all the way to the Supreme Court regarding holiday pay for part-year workers. So Mrs. Brazil was a term-time worker working for Harper Trust as a music teacher, and so she was entitled to 5.6 weeks annual leave under her contract and under statute, which she was required to take during school holidays. The trust calculated her earnings at the end of each term and then paid her 12.07% of that figure in accordance with ACAS and sort of standard practice at the time. The case went all the way to the Supreme Court, with the Supreme Court finding that holiday pay had been paid incorrectly. They found that the proratering of the holiday was not in compliance with the working time regulations, and this had the sort of adverse impact of those who are part-year workers having essentially entitlement to more holiday than they would their full-time colleagues, because then they're not only accruing holiday when they're working, they're accruing holiday throughout the year, even in periods where they're not working. The main takeaway from this is that where a worker remains under contract, they have an entitlement to 5.6 weeks holiday in each year, regardless of the amount of work done. The Supreme Court showed that the 12.07% method to work out holiday pay was irregular and unpredictable for the working time regulations. It just wasn't compatible with those. I think one of the big questions for everyone following this case is how to determine holiday pay, with I think the answer being the calendar week method. So if a worker takes a week's holiday, they should be entitled to a week's pay using the statutory formula in the working time regulations.
Thanks, Chris. I know a lot of HR teams have been really worried about the Harper decision. Are there any kind of next steps? Have the government got any plans on how to deal with this case now?
Yeah, so the government have launched a consultation. So this launched on the 12th of January this year as a direct result of the judgment, with the government seeming keen to address some potential disparity between part-year workers and full-time workers to ensure that workers are only receiving holiday pay and holiday entitlement proportionate to the amount of time that they're working. The consultation ends on the 9th of March 2023. So it'll be interesting to see just how quickly action is taken following that consultation ending. But one of the proposed calculations by the government to calculate holiday pay is calculating the hours worked in the previous 52 weeks and then timesing that by 12.07%. So we may end up in a very similar position to what we were pre-Harper Trust.
Great, thank you.
Thank you very much. I think next up is Asten running through some of the legislation that is going to be changing this year.
Great, thank you very much, Nick and Chris, and good morning, and everyone. Thank you very much again for joining us. I think we've got my first slide on the screen. So as I mentioned previously, I'm Asten Hawkes, and I'm first going to talk to you about upcoming changes in the employment sphere in the next 12 months. So you'll see on the slide our top 10 hot topics for 2023 in the legislative framework at least. And I'm going to take you through each of these in turn based on the information we have presently available. So can I have my next slide, please? So the first hot topic I want to talk to you about this morning is maternity protection on redundancy. What we're looking at here is the Protection from Redundancy, Pregnancy and Family Leave Bill, which had its first reading in June 22, and it reached its next stage as of last week. The bill is supported by the government, so it is likely to be passed, but we don't have a great deal of detail on the full scope of protections at the moment, because if the bill is passed, there'll need to be subsequent regulations with further details. What is expected is that protection will be extended in the following ways. So legal protection in relation to redundancy would be extended so that it covers the period from when a woman informs her employer of her pregnancy in writing, all the way up to the date 6 months after her return from maternity leave. There would also be an extension of priority for such individuals over other employees in any suitable alternative vacancies in a redundancy situation for that period. And in addition to that, parents who are returning or taking adoption leave, shared parental leave, and family leave are also expected to be extended those same rights. It's very much a watch this space situation, but it is likely that employers will soon need to be considering these factors in any redundancy or restructuring situation going forwards.
Asten, reading kind of reports of this bill over the weekend, it sounded like the changes would mean that employers couldn't make someone redundant if they're returning from some kind of family leave. Is that right, or is it a bit more subtle than that?
So, no, in short. I think this is the problem that you sometimes get with mainstream media interpretation on legal issues, and there are a few other points that I want to catch on that shortly. For example, I read that menopause leave had been banned in the UK, which is just not true. So let me start by saying that you can make an employee redundant during pregnancy, maternity or parental leave, but that's provided that there is a genuine redundancy situation and the individual hasn't been selected for redundancy because of their pregnancy or maternity leave. There are risks with that process, as the individual may just assume or interpret that the reason must be their pregnancy, and this is more likely if you're looking at a situation where there are still people in those roles rather than a redundancy situation where there's a workplace closure, for example, where it would be more difficult to construe it in that way. For employers, it's really about being able to demonstrate the true and fair reasoning in their process and having been reasonable throughout. And from what we know of the new legislation, obviously we're not at the passing stage yet, that isn't going to change. It's in practice, it's just essentially an extension of the period of protection in terms of duration, and also in terms of to whom the protection is actually afforded, bringing in those other types of family leave. So moving on to the other side of my slides then, we have the issue of paid leave to attend fertility treatment appointments. And this is addressed in the Fertility Treatment Employment Rights Bill. So it's another bill that's likely to pass, and its second reading is due on the 17th of March. If enacted, it will give employees a statutory right to take time off work to attend fertility treatment clinic appointments on a paid basis. And as you might expect, that would give employees protection from dismissal or detriment if they try to take that leave too. But protection would also be extended to someone who has a qualifying relationship with that individual and who's receiving that treatment to accompany that person to appointments. But the discrepancy here would be that that's unpaid time off as opposed to paid time off for the person attending the appointments. There's also a voluntary fertility pledge, which launched at the same time as the bill, which you may have seen. And this is an immediate option for employers if they wish to explore that.
I think NatWest, Channel 4 has signed up to that. But what actually is it? What does a pledge mean?
So it's essentially a sort of a sign-up voluntary situation, which, as you mentioned, a lot of big employers have signed up to already. And it essentially offers accessible workplace information and staff training surrounding fertility treatments like IVF in order to support better understanding of those issues and improve attitudes and remove stigma around it. Essentially, if you're signing up to the pledge, it's about committing to establishing fertility ambassadors in the workplace and having policies in place and sharing information and providing support and flexibility to facilitate attending those fertility treatments. So essentially, if you're signing up now, you can be signing up for things that aren't necessarily law at present, but showing a good attitude, and it can be beneficial for recruitment and also just to generally show that you're being a proactive and forward-thinking workplace. So next slide, please. So moving on to the next hot topic, which is neonatal leave. This is addressed under the Neonatal Care Leave and Pay Bill, which is already in the House of Lords for its second reading. If enacted, that bill will provide parents with the right to up to 12 weeks annual leave if their baby requires neonatal care for at least 7 continuous days, up to the 28 days after the birth of the child. This will be in addition to other types of parental and family leave that are already available. The right to leave will be a day one right, but there's only an entitlement to statutory pay for employers who have worked for 26 weeks for their current employer. And there will be an associated protection from dismissal and detriment for taking that leave. We don't have a great deal in terms of detail as yet, as there will need to be regulations to address things like notice provisions to take that leave. But there is certainly something for now for employers to think about at this early stage in terms of putting policies in place and considering whether it's preferable to potentially give rights above and beyond that proposed minimum statutory framework, again, thinking towards things like recruitment. Early indications seem to suggest that there may be a long implementation period for this type of leave if the bill does pass, and that's most likely because of changes to HMRC and payroll systems being necessary as a consequence. Before we move on, I just wanted to add a quick nod to menopause leave. So I'm sure most of you will know that it was highly publicised that the government recently rejected calls for menopause to be made a protected characteristic under the Equality Act and for a large-scale pilot of menopause leave to be trialled. So though the election hasn't been taken at this time to introduce a statutory framework, employers still can, in addition to these other points that we've been talking about, if they wish to implement this kind of leave just internally. It's not a legal right, but it could be something that you offer as a benefit to employees, which again may be a positive for things like recruitment. Next slide, please. So moving on to another type of leave being proposed, we have the issue of carers leave. So the carers leave bill was introduced in June of last year and is listed for its final stages this month and is very likely to pass. So the proposal would introduce a right for unpaid carers leave of up to 5 days in any period of 12 months, and it's a day one right. There'd also be protection from detriment or dismissal if you're taking this kind of leave, as there has been for the types of leave that I've mentioned. And as with some of the other bills that we've already talked about, this is an enabling bill, which essentially means there need to be regulations to follow to address various points. So things like notice procedures or how leave could be taken, so in blocks or in half days or something like that. What the government has indicated at this early stage is that the right would be likely to be flexible to suit employees' caring responsibilities, which is what you would expect, really, given that it is unpaid leave. We don't have a time frame here yet, but this is another topic again to consider in the review of your existing policies and in terms of whether you might want to go beyond the proposed statutory framework, for example, if you offer any paid leave. So on the other side of my slide, you'll also see paid leave following miscarriage, ectopic pregnancy or molar pregnancy. The miscarriage bill wasn't directly kind of supported by the government, but is proceeding without objection at the moment. It addresses these topics and is due for its second reading in March 2023. We don't presently have a time frame for implementation, but what it essentially proposes is a right for 3 days paid leave where an employee experiences miscarriage, ectopic pregnancy or molar pregnancy before 24 weeks. But hopefully we'll get further details about this as the bill progresses. Next slide, please. So turning away from leave now into issues of harassment. So the Worker Protection Amendment of Equality Act 2010 bill had its first reading in June of last year and is due for its third this month. It's progressing very quickly and is likely to pass. Under the scope of that bill, an employer is to be treated as liable for harassment of its employees in the course of their employment by third parties over whom the employer does not have direct control, if that employer failed to take all reasonable steps to prevent that harassment. For these purposes, a third party is another person other than an employee or the employer itself. The definition of harassment is the same as the one currently contained in the Equality Act, and the duty will be enforced by the Equality and Human Rights Commission, with non-compliance potentially leading to a range of outcomes such as litigation, investigation or enforcement action. Further to this, if an employee successfully brings a claim for sexual harassment in the employment tribunal and a finding is made that the employer breached that preventative duty, the tribunal will also have powers to award a compensation uplift of up to 25%. So this would be a new proactive duty for employers to take all reasonable steps to prevent harassment of their employees in the course of their employment, and the shift is moving towards prevention rather than reaction. Given the implications financially, it is of the utmost importance to start reviewing policies and training in the workplace, and any contracts that you may have with third parties where employees could be in contact with them in the course of their work. It's worth inquiring with them as to what training and provisions that those third parties have to understand the risks, and the earlier you start to do it, the more likely you are to be prepared if this bill were to pass. Next slide, please. So moving on to flexible working. So the government is supporting the Employment Relations Flexible Working Bill, the reporting stage for which is commencing this month. I'm sure most of you are aware, flexible working requests address things like variation to working hours, times and locations. The bill proposes the following measures. So a requirement for employers to consult with employees if considering rejecting a request for flexible working. Permission for employees to make 2 requests in a 12-month period instead of 1. A reduction in the period for employer responses to those requests from 3 months to 2, and removal of the current requirement for employees to specify in that request how their employer might deal with it. So though it's not expressly stated in the bill, the government has stated that this will be a day one right once enacted. However, coming back to my earlier point about mass media confusion, there seems to be a confusion as to the difference between a right on day one to request flexible working compared with a right from day one to have flexible working. It's the former that's proposed rather than the latter, and in practice the framework of flexible working is unlikely to change a great deal in our view, save for potentially being a little more frequent in nature with those 2 requests a year and requiring a slightly speedier response. So turning to tips and gratuities, at present there's no law which directly addresses the distribution of tips between employers and workers, but you may know it's been a hot topic for a while about unfair tipping practices, particularly in the hospitality industry. So in response, the Employment Allocation of Tips Bill has been introduced, with its final reading having taken place last month. And if enacted, this bill will require employers to ensure that all tips, gratuities and service changes which they receive or have control over are paid to workers in full without deductions at the end of each calendar month. Employers will also need to demonstrate fairness in distribution arrangements and will need to keep both records and a written policy setting out how tips are dealt with. Records have to be shared with employees on request, and employees will be able to bring a claim in the employment tribunal if employers fail to allocate fairly or within the time limit. A tribunal can then order a fair allocation, even for employees who haven't made a complaint, and the compensation for failure to provide information, keep proper records, and for financial loss attributable to the breach are each up to £5,000. There will also be a new statutory code of practice on tipping, which the tribunal will need to be taking into account in any claims if it's relevant. It's hoped that this will increase fairness for employers who already allocate tips to ensure that all employers are following the same rules. And so if you're an employer in the hospitality industry or who deals with tips day to day generally, it's best to review practices and put in place appropriate policies as soon as possible. Next slide, please. So my final couple of hot topics in the legislative sphere. So something completely different now. As a consequence of the P&O Ferries dismissal of around 800 employees last March, along with a fair number of other key businesses undertaking fire and rehire practices during and in the aftermath of the COVID-19 pandemic, the government has launched a consultation on a proposed statutory code of practice on the use of such practices. So fire and rehire practices are situations where employers envisage that they need to make contractual changes, and if the employees don't agree to those changes, it either dismisses them and offers them re-employment on those new terms anyway, or it dismisses them and engages new workers to perform the roles on those new terms. The code is around 17 pages long, and it aims to ensure employers take all reasonable steps to explore alternatives to dismissal and engage in meaningful consultation, as opposed to using threats of dismissal to put pressure on employees to accept the proposed terms. Failure to follow the code under the proposals would not in itself be a breach of a legal obligation, but tribunals would take unreasonable failure to follow the code into account and could provide up to 25% uplift in compensation to this end. Generally, fire and rehire practices have always been a risky endeavour, but as an employer, you should be thinking carefully about any proposed unilateral changes of contractual terms at an early stage to try and achieve agreement without extreme measures and associated risks being taken. And finally, the last legislative hot topic of discussion is trade unions and strike action. So this is being addressed in the Strikes Minimum Service Levels Bill, which was introduced in the House of Commons last month. Its aim is to expand previously announced reforms from the transport sector into other services. So it covers health, education, fire and rescue, transport, nuclear decommissioning, and border security. It's highly controversial. The precise scope of each service is to be defined in future regulations, but we expect those regulations to provide minimum service levels in connection with the taking of strike action. And minimum service levels here means in relation to the services being provided rather than a period of continuous service, unless that, in case that causes any confusion. So employers in these sectors will be given under this bill a power to serve work notices on trade unions that have already served them notice for strike action. And these work notices will identify the people required to work in order to maintain minimum service levels, and also specify the work to be undertaken by those individuals. If a union fails to undertake reasonable steps to ensure that those listed in that work notice don't participate in the strikes, unions could face civil liberties of up to £1 million. Employers must consult unions as far as reasonably practicable and cannot identify more individuals than reasonably necessary for the purpose of providing minimum service. And they also can't select workers based on their union membership. The hope is that voluntary agreements can be reached between unions and employers, but this may be tricky. and the impact for employers will depend on the sector, and will be more readily understood once we have further regulations and confirmation that the bill will pass. So it's certainly a watch this space situation for now, particularly as the Labour Party has already stated that if it was elected in the next election, that they will immediately repeal this. So that's everything from me for now. So thank you very much for listening, and I'll pass things back to Chris, who'll talk a bit more about EU law.
Thank you, Asten. And yeah, like Asten and Nick said, I'll be talking about EU retained law. So covering all the hot topics of employment law today, Brexit, holiday pay, and COVID-19. So we've hit all of our target topics. So the retained EU law bill is the implementation method for allowing the EU regulations or directives to be transferred into UK law. This needs to be done by the 31st of December 2023, or it will cease to be law in the UK. There is the option to extend the deadline to the 23rd of June 2026, which happens to be the 10-year anniversary of the Brexit vote. There are currently 2,417 pieces of retained EU law that are looking to be implemented, covering 300 different policy areas. So you're either likely to see a rapid amount of legislation coming through, or it's likely that there'll be a need to extend the deadline to cover all of that legislation. The bill gives ministers power to amend EU law that is retained with very little scrutiny before being implemented. So it's likely that we'll see a lot of challenge to this bill as it progresses through Parliament and through the House of Lords. So we're still quite a long way to go through Parliament for this bill. So we're not aware of exactly how that final bill will look. But there is commitment under the cooperation agreement not to weaken or reduce labour and social standards to below the levels that were in place at the end of the transition period. And so this covers issues such as working conditions, employment standards, information and consultation rights at company level. So there are still commitments to working conditions and working rights that will need to be observed by the government when looking to implement the retained EU law and when looking to make amendments to this following implementation. So if we go to the next slide, there are some areas that we may see some changes coming to in employment law. It's unlikely we'll see sort of wholesale changes at this time, but there are some areas that I think could be targeted, these being the working time regulations, CHEPI, and the agency worker regulations.
Why were they on your hit list, Chris? Why featured
So the working time regulations, we've already seen the consultation that's been announced for holiday pay for workers. So I think the government are wanting to intervene to make sure that there is no disparity between part-time workers and full-time workers, and that all workers are only entitled to holiday pay and entitlement for time they're actually working. We could also see the end of the 48-hour working week under the working time regulations, which has always been sort of unpopular with the Conservatives. And there could be some moves to just sort of make holiday pay clearer generally, and also looking at potential removal of accrual of holiday whilst on sick leave. With regards to CHEPI, it's possible that we could see this amended to become a bit more user-friendly for businesses. It could mean sort of lighter consultation obligations, and potentially allowing of harmonisation of terms following transfer, which I imagine would be popular with lots of business, but not very popular with workers generally. And with the agency worker regulations, they're often criticised for being complex and unnecessary, lots of red tape. So we could see large-scale amendments to those or complete removal. So it'd be interesting to see what happens in the near future, and also sort of after the next general election, because I think much will depend on what the political landscape is across the next few years. I mean, the current government is obviously not the most popular. So I think if they were looking to introduce wide changes that are going to have a negative impact on lots of workers' working conditions, then I think that's unlikely, because we can already see the current landscape with the number of strikes that are ongoing, and I don't think the government would want to impose more additional changes that could negatively impact large amounts of the voting population. Brilliant. And that's all I had to say on Brexit in the EU derived areas of employment law. So back over to Asten to run through some 2023 cases.
Thanks, Chris. So moving back to a few more hot topics, and this time it's employment case law. So I'm going to talk to you about 5 key cases expected to reach either the Supreme Court or the Court of Appeal this year and their potential impact. So you'll see these on the slide. And first up is an upcoming Supreme Court judgment on everyone's favourite topic, as Chris talked about earlier, underpaid holiday pay. So the judgment in the appeal of Chief Constable of the Police Service of Northern Ireland and Agnew is expected very, very soon. So what's the story so far? The Northern Ireland Court of Appeal, seemingly departing from the Bear Scotland case that Chris mentioned earlier, found that a series of unlawful deductions from wages would not be interrupted by gaps of more than 3 months, where the series of deductions related to holiday pay. So why should employers be thinking about this case? Well, if the Supreme Court rejects the Chief Constable's appeal and agrees with the Northern Ireland Court of Appeal's decision, employers across the entirety of the UK could face new holiday pay claims. These could potentially date back 2 years in Great Britain in line with the deduction from wages limitation regulations 2014, or could be even longer in Ireland as they haven't adopted those regulations, which could potentially have very costly implications. Many commentators believe that it is likely that the Supreme Court will uphold the Court of Appeal's decision, and so employers should watch this outcome with interest when it is delivered. In terms of what to do now, thinking ahead to the decision itself, it's worth, as an employer, taking stock of existing holiday and holiday pay tracking systems and making sure that these are in order, and if not, considering ways to manage holidays to avoid claims like this arising in the future. So moving on to another case expected to reach the Supreme Court at the end of this year, which is Mercer and Alternative Funding Group Limited and another. Now this case will have an impact on the scope of protection for union members taking part in industrial action. So what's happened in the case previously? The claimant, Miss Mercer, was a trade union representative and was involved in organising a series of strikes. She was suspended from work and subject to disciplinary proceedings during a strike period on the basis that she'd allegedly abandoned her shift and spoken to the media about strike action, both without permission. She was subsequently given a written warning and brought proceedings against her employer for detriment suffered as a result of her trade union membership. In this case, the Court of Appeal held that an employee who was given a written warning for taking part in industrial action could not bring a claim for detriment. However, in making that determination, the Court of Appeal went on to state that the UK's legislation in this regard may put the UK in breach of Article 11 of the European Convention on Human Rights, which gives employees the right to join a union and prevents disproportionate and unjustified actions for doing so, with the implication here being that a written warning could fall into this category. So why should employers be thinking about this case? Well, if the Supreme Court allows the appeal by Ms Mercer via her union, then this may allow employees to bring claims in the Employment Tribunal to obtain compensation for losses as a result of being subject to detriment for participating in industrial action. However, conversely, if the appeal is rejected, then the argument is that employers would be allowed to sanction employees for taking part in industrial action. It remains to be seen, however, if domestic legislation would be challenged as a consequence to address the apparent conflict with the European Convention identified. And accordingly, what we would suspect that employers should do now is to exercise caution in taking actions in relation to employees undertaking actions where possible until we have a bit more clarity on the legal position. So turning now to one further case which should reach the Supreme Court later this year, which is Croker and Angard Staffing Solutions Limited. This case will consider the issue of whether agency staff have the right to apply and be considered for internal vacancies on the same terms as directly recruited employees. So Mr. Coker brought a number of claims against Angard under the agency worker regulations. The focus of the case centres around Regulation 13, which specifies that during an assignment, an agency worker has the right from day one to be informed by the hirer of any vacancy posts and should be given the same opportunity as a comparable worker to find permanent employment with the hirer. So what's the story to date? The Employment Tribunal found in favour of Mr. Coker at first instance, but this was then overturned by the Appeals Tribunal. The Court of Appeal agreed with the EAT, noting that Regulation 13 conveyed a right which was limited to being notified of relevant vacancy posts, but did not extend to a right to apply and or be considered for that notified post. The outcome of Mr. Coker's appeal at Supreme Court level will be particularly important for employers who use agency workers and are considering restructuring of their business. It's often current practice for employers to prioritise their permanent employees before considering agency workers for a particular role, but things could change if the Supreme Court disagrees with the Court of Appeal's decision. So turning now to some cases which are reaching the Court of Appeal later this year, and the first one is Hope and BMA. So the facts of this case may strike a nerve. Mr. Hope had submitted multiple grievances, so 7 over 13 months, against his employer, but then refused to attend a formal meeting to discuss them and refused to withdraw them. Accordingly, a formal grievance meeting was held in his absence, determining that Mr. Hope's behaviour had been frivolous and vexatious and an abusive process. BMA then commenced a disciplinary procedure against Mr. Hope, which concluded that he had failed to follow reasonable instructions from the manager and that there had been a fundamental breakdown of the employment relationship. BMA then dismissed Mr. Hope with payment in lieu of notice. Mr. Hope appealed the decision unsuccessfully before then bringing an unfair dismissal claim against his employer. So what's been the decision so far? At first instance, the Employment Tribunal noted that the reason for dismissal was Mr. Hope's conduct in refusing to pursue or withdraw his variance grievances, that his employer had reasonably concluded that this was unreasonable conduct, that it had broken down the working relationship, and that dismissal was within the band of reasonable responses available to the employer in the circumstances. The main ground of Mr. Hope's appeal to the Appeals Tribunal circled around whether his actions could truly have been considered to be gross misconduct. However, this was rejected by the Appeals Tribunal, which held that there is no requirement to determine whether conduct amounts to gross misconduct, and the 4-stage test to be undertaken was whether the employer had a genuine belief in the misconduct, whether it had reached that belief on reasonable grounds, whether that was reached following a reasonable investigation, and whether dismissal of that employee fell within the reasonable range of responses in light of that misconduct. It's very much hoped that the Court of Appeal will use this further appeal by Mr. Hope in the case as an opportunity to shed some light on how employers should address grievances made in bad faith or as a consequence of potential disciplinary action. It's unlikely, however, that the court will give any indication of how many grievances and over what period of time could amount to bad faith. So in absence of that, employers are still likely to need to continue to undertake the usual process in conducting a reasonable investigation and considering whether dismissal in itself would be reasonable in the circumstances. So one final case, again reaching the Court of Appeal this year, is Fenton and Outform. So the key issue to be determined in this case is an interesting one, which is whether an employer can use a pile-on clause to unilaterally bring a resignation date forward. The facts of this case are that Mr. Fenton resigned and gave his employer 9 months contractual notice. However, 1 month before that notice was due to come to an end, his employer then exercised its contractual right to terminate his employment by making a payment in lieu of notice. By the employer doing it at that time, Mr. Fenton was then no longer eligible for a bonus under the employer's bonus scheme. So he brought a claim for unfair dismissal, claiming that he'd been dismissed by his employer by moving that end date forward. So what was decided previously? It's readily been accepted at tribunal level for some years, since a case of Marshall and Hamblin in the early 90s, that an employee's resignation is not converted to a dismissal if an employer exercises a contractual right to make a pile-on. It was a controversial decision at the time, and it remains so, but it hasn't been challenged by a court of higher stance to date. So the Employment Appeals Tribunal in Fenton reluctantly rejected Mr. Fenton's appeal on the basis it couldn't overturn that earlier case, but it did give Mr. Fenton leave to appeal to the Court of Appeal, and noted that for Marshall to be overturned, a higher court would need to hear that case. So employers should watch with interest as to whether the Court of Appeal decides to set a precedent that the use of pile-ons in such circumstances would amount to a dismissal and a new termination event. And it's not beyond reasonable expectation that it will choose to do so, particularly given how controversial the original decision was. If he is successful in his appeal, employers will need to think carefully about how they address resignations in future, and potentially how they draft notice clauses in contracts going forwards. Next slide, please. So in conclusion, I hope that you're all still with us. As we've discussed this morning, there are a number of upcoming changes and potential changes in the employment sphere in coming months. There's certainly a lot of food for thought for employers. What we would recommend is essentially conducting a review of internal procedures, contracts, policies and systems as soon as possible. As you can see on the slide, review. Within that exercise, you can consider any areas of risk or improvement. So, for example, in relation to holiday pay and leave tracking, as well as any areas that you might wish to build on, such as neonatal leave and pay. We remain readily available if you need any advice on those issues, or if you need any help with the reviewing process. But thank you very much for listening, and that's everything from me. And I'll pass things back to Nick now.
Brilliant. Thanks very much, Asten, and thanks a lot, Chris. As we've been kind of talking, we've had some questions. One of them that's come through, I think, is for you, Asten, which is, why do you think like menopause, miscarriage, ectopic kind of pregnancies have been carved out from existing kind of medical leave and pay provisions?
So I think I'll deal with menopause leave first. I don't know if you've seen any of the kind of media outlets on on whether people thought that it should be approved or not, but the resounding figures seem to suggest that people didn't want it to apply, which I found quite surprising. The reason that it had been proposed as a protected characteristic at first instance is because of the difficulties that there are in essentially arguing direct or indirect discrimination with the current framework. But the issue is balancing and understanding the situation further. I think that even though we are getting more progressive, menopause and miscarriages are still a topic that people don't necessarily like to readily talk about in the workplace. And I think people, somewhat cynically, are more likely to want to address issues that they have to think about day to day. And it is something that affects a wide scope of people. And I do think personally that they should be protected. But I think we've got some ways to go before these issues are considered at a legislative level to be protected in the same way as things like parental leave, which obviously affects more people, given that it may affect the full population rather than half.
And I know one of the kind of areas that I know a lot of people have been kind of thinking about that will be coming in is the changes to flexible working. Again, have you got kind of any feel as to when those changes may actually come in?
I think sooner rather than later, but I think, as I mentioned before, I don't expect there to be masses of changes in the actual framework itself. I think it's probably slightly like the kind of data protection situation where everyone is thinking, oh, there's a mass change coming, and therefore it's going to be such a hot topic and everyone's going to be taking steps and doing all of these things. But I think perhaps people that are thinking that it's going to be a massive change are either those people that think that now suddenly there's a day one right to flexible working, rather than a right to request. But I think from that, even if it were to be a kind of day one right, I think if you were looking at people who are applying for new roles at a company, I think in the post-COVID-19 world, if people are looking for flexible working, they're probably likely to raise that in an interview, because I think that the change in terms of what people are looking for has been as a consequence of the way that we all adapted to the pandemic. And so it may be a situation that we're moving away from that concept entirely, in that people are saying, okay, well, I'll accept the job, but only if I can work, 2 days in the office per week. And then it will be a case of whether an employer is prepared to do that, or potentially lose the potential recruits. So in practice, I'm not sure how much it really provides in terms of new changes, but I suspect that just in adapting to those new working practices, that companies may choose to bring those points forward in any event.
Oh, brilliant. Thank you. Well, thank you both for covering so much this morning so clearly. I think it's been fantastic. And thank you also to Megan, who's been working really hard behind the scenes to make sure that everything ran smoothly this morning. And thank you also to all of you for joining us. It's been great to kind of be able to present these kind of new changes to you. As I mentioned, we'll send out an email in the next few days providing a fuller response to the points that we've discussed, together with a recording of the webinar and the slides. We're going to be hosting another webinar very shortly, so please do look out for the invites. In the meantime, I'd just like to thank you again for joining us today, and have a great day, and we look forward to joining you and seeing you soon. Thank you very much. Goodbye.